Alrighty, everyone. Hello and welcome to Phoenixville Library. Those of you in our community room and those on our Zoom channel. Tonight, we're pleased to have back with us Kelly Young from who is a staff attorney with Legal Aid of Southeastern Pennsylvania, talking about a topic that has been pretty popular and looks like it is again, the basics of landlord-tenant law and eviction defense. Those of you on Zoom, please type any questions during the presentation into the chat and I will relay them to Kelly. Those of you in the room, feel free to ask Kelly questions at any time. At the end, those on Zoom, you can get a chance to unmute yourself to ask a question if you prefer doing it that way. All right, without further ado, take it away, Kelly.
Okay, thanks, Mark. Hi. My name is Kelly, like Mark said, and also like Mark said, please feel free to interrupt with a question. I'm always happy to have the question at the moment when we're already talking about that issue. And then if it becomes something that's a little too personal, I'll say, well, maybe let's wait till the end to talk about that, or you can give our office a call. But if it's something general, then I certainly welcome that. So we're going to talk about the basics of landlord-tenant law and what you might do if there is an eviction case against you, and just how eviction cases work in general.
So just a quick question, is this more dedicated toward a renter or to a landlord?
Yes, that's a good point. I have to apologize for any of my previous presentations that have been, maybe I said some things that were a little harsh towards the landlords. We all have to be grateful to people who are landlords, who are willing to take on that job, who are willing to rent out a property that they own, which is not always an easy thing to do. But from my job is to represent tenants in court. So from my point of view, I'm usually dealing with situations that are very difficult for a tenant, that are potentially unfair, maybe a landlord that isn't willing to negotiate. So yes, this presentation is going to be a lot of information for tenants, but it can also be informative for landlords, because it's always good as a landlord to know, the way the relationship works, what would have to happen if there was a problem, and then how to avoid that. Because if at all possible, it is always best to avoid eviction court. It's really just stressful, it's really just no fun. I love when both parties can sit down and have a conversation and mediate and see if they can come to a mutual agreement. Unfortunately, with the current atmosphere, there's just not enough housing. The housing that there is just is not affordable, especially for the people that I work with. At Legal Services, we have we're income restricted. So, I do talk with a lot of people who are experiencing very difficult circumstances. Maybe they've been asked to leave pursuant to a non-renewal, but there is nowhere else for them to go. And in those situations, sometimes they take advantage of the court process as additional time before they experience homelessness, which is just a tragedy. So thank you for the question. So when you're dealing with landlord-tenant situations, you are going to be under the Landlord-Tenant Act of 1951. I have the packet right here. I know only the people in the room can see it, but feel free to take a look at it. Quite old at this point, but it is still the applicable statute that gives information about what court has jurisdiction, how much notice needs to be given by the landlord, information about return of security deposit, and return of personal property after a tenancy is over. We're also going to be guided by the Fair Housing Act. We're not going to have time to really touch on that today. It's a topic of its own. But the Housing Equality Center has great information on that. Pennsylvania common law, and the most significant case is Pugh v. Holmes, which is also here today if anybody wanted to look at it. But you can just Google Pugh v. Holmes. You can Google Landlord-Tenant Act and you can find these PDFs. Few V Homes is about the condition of a rented property, how habitable it has to be. And also very important are the procedural rules for court. So those are at PA RCP MDJ 100 to 1082. There's a portion about civil claims, then there's a portion about recovery of real property. That's landlord tenant, because as a landlord, your goal is to recover your possession of your real estate. And finally, so important, your lease. A lot of times people have a dispute and they come to me and they say, I don't know what to do. And I say, well, did you look in your lease? And they're like, well, no. Because you sort of sign the lease and then you forget about it. And you need to always keep a copy of the lease and keep it in an important place. Don't lose it. Okay, so in the Landlord-Tenant Act, you're gonna be focusing on Article 5. I really already explained that we're gonna talk about if there is a dispute, how must the landlord proceed, who presides over the dispute, which judge is gonna be in charge, how will the tenant be notified that they're, being, not that they're being evicted yet, but that the eviction process, which is a process with multiple steps, is starting. And do they have an opportunity to cure the default, which means fix the problem and stay in the home. Okay, I like to think of it as there are 3 different problems that can arise. Non-payment, and all these things, they're alleged, they're just alleged until they're proven. So, non-payment, lease violation, or the lease term is over. In Pennsylvania, all landlord-tenant actions are brought in the lowest court, which is the magisterial district court. If you're in a place like Philadelphia, this is going to be called municipal court, but it's the same thing. Magisterial district courts are accessible to everybody. You do not need to be a lawyer to bring your case in one of these courts. The judges are used to pro se litigants, and pro se means acting on your own behalf. In Chester County, there are somewhere around 16 or 17 of these courts. There's one in Phoenixville that covers the borough and the surrounding counties. There's one next door in Pottstown that covers Spring City and the surrounding, and when I say counties, I mean townships, and Exton and Downingtown and so on and so on. So wherever the rented property is, that's where an eviction case would be heard. You can appeal a magisterial district judge's decision. There's always an appeal possibility. Appeal would be up to the Court of Common Pleas, which is a county court in Westchester. The first level there is called arbitration, and you can appeal yet again from your arbitration decision to a trial before a common pleas judge. All right, in an eviction, a lot of people call me and they're really upset and they say, I got a piece of paper from the landlord, I'm being evicted. And it is scary, I don't want to diminish that, but you're not being evicted right now. First, there's a notice to quit. The landlord is required to give to the tenant, unless it's been waived in the lease, which is not good for either party. It's always better to give the tenant a notice and have a chance to cure the problem, discuss the issue. The landlord is required to give the tenant a notice. It's just a piece of paper, says, to the tenant from the landlord, and it tells them what the problem is, and it tells them to quit. So typical example would be the 10-day notice of non-payment of rent. And that's what's required in the Landlord-Tenant Act if the notice is not waived in your lease. And it would simply say, Kelly, you owe $1,500 in your rent. You have 10 days to either pay this or quit. If the money's not paid and the tenant doesn't quit by that date, only then can the landlord bring an eviction complaint in court, not before then. The magisterial district judge technically has no jurisdiction over the case. until the quit date has passed. And again, if anything I'm saying is confusing or like jumbly, just please interrupt me. Because I do this all the time, so it's like second nature. So you receive the notice to quit. It says, Kelly, you owe $1,500, pay or quit by September 8th. Well, I try to come up with the money, but I can't. And I don't leave either because I can't afford to move. And maybe I have kids, or I have dealing with a disability. Or, I lost my job, and I'm trying to get another job, but it's just not happening that quickly. Well then, the day after the quit date, the landlord can file a complaint in the local magisterial district court. There will be a week to 2 weeks until the hearing. So I will receive notice. I'll receive a hearing notice that tells me what time and what day and what court I can go to, and I'll receive a copy of the complaint. These things will be delivered by constable and or mailed to the tenant.
I'm sorry, what was that called? You said after, the day after the quit date, it's the...
So the landlord files what's called a landlord-tenant complaint. It's a little confusing because the packet from the district court includes 3 papers. One says recovery of real property hearing. The other will say landlord-tenant complaint. And there's some associated papers that are less important. But the tenant will get notice, and the tenant should get notice at least 5 days before the hearing. So if for some reason you get this information from the constable and you look at it and the hearing is in 3 days, and you're like, oh my gosh, it's only 3 days, how can I prepare? You should contact the district court and say, I only just received this, and I know there has to be 5 days until a hearing, so I'm asking that it be briefly rescheduled. You can always reach the district court at the phone number on your paperwork, and also by email. They'll give you their email, but it's district court, whatever number they are, at chesco.org. So for example, in Coatesville, it's district court 15103 at chesco.org. And you can just email them. They're usually very responsive with any questions that you have. So you get notice of the hearing, you have to go to the hearing. Yes.
So you said the constable, what comes out to the person's house?
Yes, the constable's job is to serve the complaint.
And how if the constable, the person isn't home, then what?
Well, I believe that they try a few times. If they're unsuccessful, then they would return to the district court, note down that they were unsuccessful, and then try again at a later date. Or they'll post. Posting is fine, or handing to another adult at the premises. And they will also mail a copy. So it's unlikely. I've also had people concerned that they're going to be sued and they're not going to know. Unlikely. You're going to know. I've been in this job for 5 years, and I've hardly had anybody say that. All right, when it's time for your hearing, it's nerve-wracking, but you should go, because like I said, the magisterial district court, you don't need a lawyer to access it. You can always call legal aid. That's what I'm there for. There is a high demand, so we'll definitely assess the case. We'll definitely give advice. If I can come, I'm happy to come. But if there's no legal defense or we're just inundated, then I will give advice for how a tenant can do this on their own. The other reason to go to your hearing is that's your time to speak for yourself, to speak on your behalf, and it doesn't have to be contentious. You can be polite, you can be professional, but you're explaining your side of the story to the judge and the landlord. That's the only people that'll be on the room. The judge, the landlord's lawyer, if the landlord hired a lawyer, but that's usually quite expensive, not always necessary, and then the tenant, and possibly the tenant's lawyer, if the tenant hired a lawyer. After the hearing, the judge will issue a decision within 3 days. The decision will come to both parties by mail, and if either party is dissatisfied, they can appeal. Now there's 2 types of appeals. If you're a tenant, you can appeal the monetary only portion of the judgment. So maybe there's a judgment that says, you need to leave, and also you owe $1,500. Well, I can say, okay, I'll leave, but I disagree. I don't think I owe you $1,500. So I would have 30 days from the date of the judgment to file my monetary only appeal. But if I am really between a rock and a hard place and I can't imagine leaving, you know, being evicted, I don't have anywhere to go, I think I'm gonna get a new job and catch up on rent, I have, you know, kids in the school district, whatever the situation is. If my goal is to stay in the home during the appeal, I can do that, as long as I pay ongoing rent. In that case, the deadline to appeal is 10 days. It's really quick. From the date of the judgment to the deadline, 10 calendar days, not business days. And appealing is just a matter of paperwork. You fill out a lot of paperwork at the Court of Common Pleas in Westchester, and you pay your rent. And there will be another hearing to rehash the issue in 6 months. If there is no appeal, then the landlord can proceed to the next step, right? The hearing's been had, the decision's been made, no appeal's been taken, then the landlord can request the order for possession, which is an eviction order, which is a terrible thing, but it gives you a time and a date that you will be required to leave the home. And if you're not moved out by that time, the constable will come and escort you off of the property. The order for possession you'll have 10 days notice. So, you know, if you get one on the 1st, eviction would be for around the 11th. So it's not gonna be a piece of paper that says, get out tomorrow. You're gonna have 10 days notice so that you can make arrangements, pack your things. You should take as many things as you can, or you can look in the Landlord-Tenant Act about how to regain personal property, which is almost impossible. All right, so that's the court timeline. I want to go back to the complaint itself. The complaint is the most important. This directs the hearing, because if it's not pled in the complaint, it's not at issue in the hearing. You know, sometimes a landlord will plead on the complaint. So remember, there's 3 things. It could be an allegation of non-payment of rent, could be an allegation of other lease violation, anything, or it could be an allegation that the lease is over, it ended, and the tenant didn't leave. So sometimes a landlord will allege only non-payment of rent. And then at the hearing, emotions are high, everybody's frustrated, and the landlord starts saying, well, also, you have a dog, and you did this, you did that. If it's not on the complaint, it's not appropriate for the magisterial district judge to be considering it. So a tenant would speak up and say, respectfully, and you can hold up the complaint. I actually brought a copy of all the different pieces of paper in case people wanted to see them. But you know, you can hold up the complaint, you can say respectfully that the only allegation against me is non-payment of rent. So we should only be talking about non-payment of rent. A landlord does have a right to amend their complaint, but they can't do that just in the moment. You haven't had a chance to prepare your defense. So if they're saying, oh, well, I'm adding it to the complaint, you have a dog. Well, then you can say, okay, the magisterial district procedural rules, allow me a continuance now to prepare my defense for this new allegation.
So I have another question.
Sure.
So when it's something not like rent, it's a violation of some other, like you have a dog and you're not allowed to have a dog, and you said when it was rent, there was a period of time to quit. So what is the period of time to quit on something that's just a violation of something in the lease?
Good question. So in the Landlord-Tenant Act of 1951, Article 5, Part B, it says, except as provided, blah, 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 in the case of the expiration of a term or a forfeiture for breach, where the lease is for the term of 1 year or less, the notice shall specify that the tenant shall remove within 15 days from the date of service.
So it's 15.
And when the lease is for more than 1 year, which is rare, then within 30 days. In the case of failure of the tenant to satisfy any rent, the notice shall specify 10 days.
So it's 15 if it's less than a year, like it was a year lease.
Right, if
But
it's a
if,
year
let's
lease.
say they renewed or whatever, and they're in year 2 or 3 or whatever, then it's 30?
No.
Oh.
It's so, the way that they write this is unnecessarily confusing, but
No, if you have like
if
a
you're,
2-year lease.
if you're
then
in,
it's 30.
if you're in a 2-year lease, they would need to give you 30 days notice to quit. But if you're in a year lease term, regardless of whether it's your first year in the property or your second year in the
Okay.
property or your third year, there would need to be a 15-day notice to quit for, according to this, for a violation other than non-payment.
Okay.
For non-payment though, only 10. That said, you know, I tell tenants, read your lease because many leases waive the notice to quit. Now, if
Oh.
there's a waiver, it's supposed to be bold and obvious, and it's supposed to require a tenant, you know, signature. But oftentimes, especially in these 40, 50 pagers from corporations, it's just buried in there, page 39, you know, 8-point font, you would never see it. And you can make the argument to the so what's gonna happen to a tenant in that situation is, they might not get the notice that tells them, hey, we wanna have a meeting with you. We feel that you've done X, Y, Z wrong. They might just get sued. And I you know, that's terrible, because maybe there could have been an opportunity to work things out. But in that situation, if you just get sued one day, and you're looking at the complaint, and you're thinking, oh my gosh, what am I gonna say at my hearing? You can bring up the fact that, Your Honor, this is my lease, it's 60 pages. There is a waiver in here, and I can, you know, it wasn't visible, right? And, you know, I think that that's inappropriate. Every magisterial district judge is different, because they're all people just like us, and they all have, you know, thoughts about how these things should go. So a lot of them they're not gonna let that argument fly. They're gonna just say, well, it's your lease, you should have read it. But some of them might credit that, and then you might be entitled to some additional time. It's worth bringing up. So I have 2 samples up here. I think probably only the people online can see them clearly, but the complaint on the left is just for rent. And that's why just the rent box is checked. They make this process so easy, it's really just check boxes. The complaint on the right is for rent and forfeiture. Forfeiture has resulted by reason of a breach of the conditions of the lease, again, not necessarily wordy. Pet violation. Okay, so you have your complaint, you know what the allegations against you are, and you're getting ready for your hearing. In your hearing, the landlord always goes first, because the plaintiff always goes first. And it can be frustrating, you know, I've been through it many times, especially if the landlord is, you know, kind of aggressive and unyielding. It can be frustrating to sit through that, but it is very important to be patient and professional, because the magisterial district judges aren't gonna credit your arguments anymore if you can't wait for your turn. So while the plaintiff is presenting and saying whatever they want about the things that you have done wrong or allegedly done wrong, you can wait, you can take notes about what you want to respond to. And when it's your turn, you tell the judge whatever you wish. But focus on what's in the complaint. You can provide printed evidence. So for example, if it's an allegation of non-payment, bring your receipts. And bring all of your receipts. You know, sometimes there's an allegation that $1,000 is owed, and you bring your $1,000 of payments for the last couple months. But the landlord shows up with a ledger that shows the $1,000 is from previous. So just bring all the rent receipts that you can. Ideally, you will bring 3 copies of everything. Copy for yourself, copy for the landlord, copy for the judge. Because it's gonna be easier for everyone to follow along. You don't wanna be running around the room, sharing the paper with everyone. It's just messy, and it doesn't look professional. You can bring witnesses. So maybe you don't have rent receipts because you don't bank. You know, maybe you just use cash, and you put the cash in their mail slot in their door every first, you know, I don't know. You hear all different things. I actually had somebody who did that and who didn't drive, but a friend would drive her every month and put the money in the slot. So the friend came as a witness, and you call your witness up to the stand and you ask questions, open-ended questions, so that the witness can testify. So you can ask, can you explain how I pay my rent every month? And they can say, yeah, you know, I pick you up at your house and we drive to blah, blah, blah address, we put the money in the door. The witness, you know, you can't put words in the witness's mouth, so always ask open-ended questions. And then the judge gets to decide behind the scenes if he or she thinks the witness was credible or not. That's the judge's call. There's so much more to say about a hearing. Does anybody have any questions about what would happen at a hearing? Sure.
Just a quick question on
Yep.
the topic that we were discussing earlier, no jury trial.
No jury trial.
Yeah, I just pulled up my lease
Mhm.
and I just want to understand this one.
Okay.
It says owner and resident waive their right to a trial by jury
Okay.
in any action or proceedings brought by either against other for any matter concerning this lease or the apartment. What does this mean? Let's say if I have an issue and I want to bring it to the court,
Mhm.
can I or can I not?
Yeah, good question. And actually, most leases that I see nowadays, if they're the longer form kind, will say waiver of jury trial. And that doesn't affect a whole lot, because you always start at the magisterial district court level, and there's no jury. There's only a judge, the magisterial district judge. Even on appeal, when you go to the first appeal level, there's no jury. There's only arbitrators. It's only at the third hearing, which would be your trial by common pleas judge, where there could be a jury. So in that case, you know, you wouldn't have a jury, you would just have the judge. But
So
you
I
know,
can.
it probably wouldn't even get there. And if it did, you could still have a trial, certainly. Just wouldn't be decided by a jury of your peers. Yeah. All right, we can come back to that if anybody has questions. You definitely want to bring 3 copies of your lease to the hearing. One of the things that frustrates me is that a lease isn't required with the filing of the complaint, you know? Landlords will fill this out and file it, and sometimes the information indicated is not accurate. And if a lease were required to be provided, that could easily be seen. You know, you need to indicate monthly rent, security deposit. But yeah, it's not a requirement. And I have seen hearings go forward where a landlord shows up as the plaintiff and says, this is the rent, this is the arrears. Maybe the tenant doesn't have any paperwork to contradict that, or maybe the tenant doesn't show up because they're nervous for whatever reason. And the magisterial district judge will just enter a judgment for the landlord without even asking to see the lease. So as the tenant, bring a copy of your lease to the hearing, and bring 3 copies if you can. You can always make copies at the library.
Yeah, sure. So can I ask, how long does it take from the time that you file to actually get that first encounter with the magistrate? Are the courts very backed up with this, or is it relatively easy?
Good question. So if you read in the magisterial district court procedural rules, it specifies that a hearing must be held within 30 days of the filing of the complaint. But they're never scheduled a month out. They're usually scheduled a week to 2 weeks out. So if somebody sues me today, I'll have a hearing, you know, September 10th or around there. The other thing is, if you receive notice as a tenant of a hearing date and you have something else very important pre-scheduled conflicting with that hearing date, don't be shy to ask for a continuance. You just email the district court, you just provide your case number, and you say, you know, I'm defendant Kelly Young. I had, you know, an important cardiology appointment at the same time as the hearing, and I really can't miss it. I'm asking for a brief continuance. and then it's at the judge's discretion. All right, I think I'd like to move past this. This is about the notice to quit, which we already talked about. Here's an example of a very tiny waiver, although this one is on page, oh no, that's page 4 of 8. So, you know, you might not see this. Tenant might not see this. You should always read your whole lease. Don't just assume it's fine and sign it. 24A, it says, landlord shall not be required to give tenant a notice of default or an opportunity to correct any default. Tenant waives the right to receive a notice to quit or a notice to vacate. So, you know, there you've signed away your chance at a discussion before court.
Right.
And one of the other things that really frustrates me is that once there is a court complaint filed, that's a public record. So it's hard out there for tenants. There's a lot of competition. Sometimes you need to go to court because it's the only way for you to advocate for yourself and have your side of the story heard. But there's gonna be a public record, essentially forever, of the fact that your landlord filed a case against you. And more landlords will hire private screening companies to provide a grade for the prospective tenant. And it's sad because I meet a lot of wonderful tenants who just really fell on a hard time, and now they have an eviction filing, and now every time they try to rent, there's gonna be someone else who seems more desirable who doesn't have one. So I would say to all landlords, you know, take those with a grain of salt, because they don't necessarily mean that it's a bad family to rent to. All right, so let's move on. Okay, yes, your lease rules, and your lease is the usually be all end all of the situation, but there are things in there that can be unenforceable. Often I'll see a lease say, tenant accepts the property as is. You know, the tenant is okay with the condition. You should check the property before you move in, make sure that you're okay with the condition. But let's say you've now been living there for 6 months and the ceiling caves in because there was a leak and there's water damage that wasn't addressed. No, you're not accepting that as is. You know, you're entitled to a habitable home. Doesn't have to be a nice home, but it has to be a habitable home. So if a landlord who's particularly difficult comes back at you, and maybe not for a ceiling, that's an extreme example, but maybe for you know, some there can be dangerous floor if the floor is rotting away or giving in some spots, and you say, this is a problem for me. And the landlord says, well, look at your lease. It says you're fine with the condition as is. That's not necessarily true. It has to be habitable. I have seen leases that say, there's no need to go to court. We can just put you out. That's not true. That hasn't been true since 1951. And no police officer that I've ever spoken to, they know not to do that, right? Sometimes the landlord just tries to threaten because maybe they're frustrated too. Maybe they're having money problems. And they say, you gotta get out by tomorrow or I'm gonna change the locks. Absolutely not okay. And if they called the police and said, you know, this person has to leave, you show proof of residence, you show your lease, you say I've been living here for X months, and the police will not lock you out. They will say to the landlord, look, this is a civil issue. You need to take this to court. Late fees are often an unenforceable penalty instead of an appropriate liquidated damages clause. So if your lease says that your late fee is $100, that's fine. That's your late fee. But if your lease says that your late fee is gonna be $50 a day, that's not appropriate. That's just a scare tactic, and you can argue against that with the magisterial district judge. So I see that quite a bit. I'll see leases that say on the 6th day, there's a $50 fee. And every day after that, it's an additional $25. Well, no, your argument to the district judge is the only appropriate late fee in my lease is the $50 fee. And I will pay that and I take responsibility for that. But the additional amount is unenforceable penalty. under Pennsylvania law. Okay, lease term is another thing that I find really confuses people. When you move in and you sign a lease, it will say January 1st to December 31st, 2025, right? But then like, you just keep living there. You just keep living there and time moves on. And so what happens in April 2026? You know, where are you at that point? Well, it depends on what it says in your lease. Most leases will have a renewal clause, and it will say this lease automatically renews month to month. So then, there's not a whole lot of security in that. You're month to month. Your lease is constructively starting on the 1st, ending on the 31st, starting on the 1st, ending on the 31st. At any time, your landlord could issue a non-renewal, which is devastating because it's not just it is just a contract, but it's more because it's your home. But there are situations where a landlord will issue a non-renewal of lease and the tenant calls me and is very distraught and says, I have 4 kids, I don't know where I'm gonna go. And I say, let me take a look at your lease. And in the renewal clause, it says this lease automatically renews year to year. So, you know, if you're in the example that I gave, January 1st, 2025 to December 31st, 2025. Say 3 years go by, all is well, living in the property, then, you know, my kids do some damage or whatever. And I get a notice, 1 August, we're not renewing your lease. You need to leave by the end of October. And I'm feeling really like upset about that. Check your lease and make sure that the landlord is correct about the term. It's not rare that they're wrong about the term. There are specific management companies that I can think of who frequently get the term wrong, whether that's because they don't care and they're not checking, or because they just have too much to do. But you should, you know, you don't need to have a new lease signed every year. You can, that's great. That means that both parties are keeping in touch and staying current on their responsibilities. But even if you don't, you still have an underlying lease. All the terms in your original lease still apply, although the dates might be expired. You can just get a calendar out and count forward to determine what term you're in now. Okay, this is a really major issue, the implied warranty of habitability. And I would recommend the Housing Equality Center's Know Your Rights booklet, which you can find online. I didn't have any copies to bring today, but it has so much information, and I specifically like the implied warranty of habitability section, which is why I added images of it here. Pew v. Holmes tells us that the landlord has a duty to provide a habitable home to a tenant. So again, it doesn't have to be nice, but it has to be habitable. Well, what do you do if it's not habitable? Very specific things. You can't just get frustrated, get upset, throw your hands up in the air and stop paying your rent. Not gonna work. You need to do very specific things. First, you look at your lease and see what the lease says, because some leases will require a specific method of notice. Like, you need to report this through our portal, or you need to send an email to this specific maintenance email address. But you're gonna notify in writing. Whatever specific method that is, just definitely go by the lease. But if the lease is quiet on that issue, send an email or mail a letter. And maybe you can mail it so that you can track it in some way. Or you can physically hand it to the management and say, hey, I wanted to talk about this, and I'm also giving you this letter as a follow-up. The letter should be clear about what's wrong. So the plumbing is causing a problem, the drains aren't working. Or whatever it is. Don't go on and on and on for pages. Just be concise, be clear, this is the problem, and ask for help within a certain period of time. And you determine the time and you be reasonable. So if the problem is, this is the example I always use, you have no heat and it's winter, then you can say, I'm asking for assistance within 24 hours. It's 50 degrees in the house. If the issue is that, you know, the bathroom shower doesn't work at all, but you have another shower, you can say, you know, can you assist within a week or 2 weeks, or whatever you think is reasonable. The key is to be reasonable. Both parties should try to be reasonable. So you send that writing to the landlord, and maybe the landlord fixes it and everything is great again, fine. And then everybody's friends. But if for some reason they don't attend to the problem, then you send a follow-up and you say, I'm writing again because I haven't heard from you and I have the same problem. I'm gonna need to escrow my rent until the problem is fixed. And then you put the rent in a separate bank account. Maybe you have a savings that you don't really use. Maybe that's just me, but you put it in there on the 1st, so that down the road, if you're in the magisterial district court, you have a piece of paper that you can share as evidence. Not just, you know, testimony's fine, but it's better to have testimony and documentation. So it's not just you saying, oh my gosh, there's no heat, there's no water, the roof caved in, and then there was a bear in the house. Like, then you have your first letter to the landlord, your second letter to the landlord, your bank statement that shows that on August 1st, September 1st, and October 1st, it's not that you didn't have money, it's that you escrowed the money. And you can bring pictures if it's something that you can take pictures of.
Do they have to say that they're escrowing?
Well, I think it's a good practice. In the first letter, you don't want to just be threatening things. You know, you want to be reasonable. So you want to say, hey, I'm having this problem. And maybe you don't just send a letter, maybe you talk, because what people normally do with each other is they talk. But you always want to follow it up with something in writing in case you get into hot water. So in the first letter, no need to talk about, you know, if you don't fix this, I'm going to escrow my money. You can just say, I'm having this problem and I need some help. In the second letter, which comes if there's no assistance within the requested time period, then yeah, it would be good to say, I'm not going to pay on the 1st because I don't feel that it's warranted. The property's not habitable. Now, big disclaimer, I would only do this if you are in, it's up to you ultimately, but I've seen sad situations, and I wouldn't recommend doing it if you are in a month-to-month lease, because you don't have any security. You just really don't have any security. But if you're in a year lease, and your lease isn't over till December, and here we are in May, and the toilets aren't working, then you're gonna have to escrow your rent to put some pressure on the owner of the property. There's a lot of owners out there who don't need any pressure. They're gonna come running to help you because they care. You know, they wanna maintain their own property, first of all, because they have equity in it, and they wanna help you. But there are situations where maybe they're absentee landlords or an LLC who really doesn't care about the condition of the property. And yeah, in that situation, you might have to escrow. That's only the first option, escrow. There's another option, which is repair and deduct. So maybe the problem is that there's heater maintenance that needs to be done, and that will fix the heating problem. And you had someone come and they said, okay, easy fix, but it's gonna be $250. Well, in your second letter to the landlord, you can say, I need heat, so I'm gonna be paying the $250. I'll keep the bill, and I'm gonna deduct that from my next month's rent.
Yeah, you're allowed to do that.
Now, when I say you can do that,
But you have to.
you know, you can do whatever you want. You
Well,
can
no,
do it.
yeah.
But it might cause a landlord to file an eviction, right?
Yeah,
So the
right.
landlord's sitting over in their office looking at the ledger,
Yeah.
and they're like, what? I only got $1,000 this month instead of $1,500.
Right.
I'm gonna file an eviction complaint.
Okay.
Maybe they look in their lease, there's no notice required, so they're just running over to the district court and they file the complaint, which, by the way, costs the landlord like $200. So it's not a smart business decision, but, you know, you could be in a situation where, unfortunately, because you had to enforce your rights, there's now this civil record against you. But you're prepared for the hearing, and you come to the hearing. You bring your first letter, bring your second letter, you bring either your escrow statement or your repair and deduct receipt, and you say, and you testify about what happened, and the timeline is very important. And if everything is in order, the case against you would be dismissed.
So then is it on the record still, or?
Yeah.
Yes, so there's always gonna be a record that says
Mhm.
Bobby versus Kelly.
Right. So it's
But
like-
if somebody clicks into the record, they'll see, oh, it was dismissed.
Mhm.
Bobby didn't get anywhere with that, so Kelly must not have done anything that bad. Or it could say settled. You know, there's different outcomes. Once a landlord-tenant complaint is filed, there are several different outcomes. There can be, and we're gonna have a slide about that, but since we're on it, there can be just a money judgment. There can be a judgment for money and possession. There can be just a judgment for possession. There could be a dismissal of the claim. You know, maybe the landlord was completely wrong. They did one of these things where they issued a non-renewal of lease in the middle of the lease term. Well, dismissed, because that's not allowed. Or it can be marked withdrawn. Maybe you talk with the landlord, you can always talk. It's never too late to talk. Sometimes I talk to landlords right in front of the hearing room. And we're like, you know, this isn't good for anybody. This is just gonna end in a judgment against the tenant, then the tenant's gonna appeal, and then this thing is gonna drag on for 8 months. Easy for it to drag on for 8 months. And it's gonna be a nightmare. So why don't we just write this up? You know, the tenant will pay an extra $500 and they'll vacate at the end of the month, and we'll just call it done. So sometimes it's marked withdrawn by the landlord or settled. I think those are the only options there.
So just on that, so on the landlord side, if it does go on 8 months and they're not getting paid and the person is living there, like what is their recourse?
Good question.
And ultimately, even if the person moves out, how about they don't have the money to pay? I mean, you can put a judgment or a lien or whatever, but like if they don't have the money to pay, how does the landlord get the money?
Yep, and that's often the case, because if your tenant doesn't have the money to pay, it's not because they don't want to. It's because they're struggling. And so landlords can say all they want, you know, oh, I'm gonna get money judgment for $6,000. Okay. It's like, who cares? So that's a good question, and the answer is, no, it can't continue for 8 months without the landlord getting any compensation. Remember when I said when the tenant appeals, if the tenant wants to appeal and continue possession until the next hearing, ongoing rent has to be paid. So ongoing rent gets paid into the court, and the court holds that money. If the landlord is struggling, the landlord can petition the court. It's just a form, and say, I own the property, I ask that the money be released while the appeal is pending. And then the judge will review it, and the judge will either say yay or nay. And so plenty of times, a landlord gets their money released to them in an ongoing way while they're waiting for the appeal hearing. Which is helpful, because a lot of landlords are paying a mortgage with the rent.
Right.
And a lot of times, everyone in the situation is struggling. Okay, so this is what I was talking about before, how to document your habitability problem. Remember, only do it if you're safe in your lease, and only do it if you have a serious habitability problem, not if you think the carpet is ugly, because you don't have a right to a nice carpet. And I have a warning at the bottom. Note, only do it if it's serious, because escrowing rent, like I said, can prompt the landlord to file a lawsuit for unpaid rent. So
But technically, it's not failure to pay rent, they're paying it, so like.
Well, they're paying it into escrow. So if the
Right.
landlord doesn't have it, the landlord can go over and fill out a claim that says, you haven't paid it to me.
Right. Oh.
I've seen it plenty of times. All right, so this is a slide with a picture of, so first, there's the complaint. This is what the landlord would file to get a hearing. Then there's a hearing, and then there is a judgment. For some reason, it's called Notice of Judgment Transcript. And like I listed on my fingers, there's lots of different types of judgments. The one on the left here says, this is what I call a pay and stay. Possession is granted, again, unnecessarily complicated. Possession is granted, and at any time before actual delivery of the real property is made, blah, 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 the defendant may, blah, 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 satisfy the order for possession by paying rent due. So this is a judgment for money and for possession. But because the only claim was money, it's curable. The tenant is going to have an opportunity to pay that and stop the final step of the process, which, remember, was called the order for possession. So, you know, it's possible that you go through the whole process. You even maybe get the order for possession served on you because you didn't appeal. And then you come up with the money and you pay it all to the constable, and then there's no eviction. But emotions are high and the relationship is probably irreparably harmed. Then there's another type of judgment which I call straight possession to indicate that it's not curable. That's not a technical term, that's just what I call it. But it'll say possession is granted and the defendant is not permitted to satisfy the order for possession by paying the rent in arrears. So if you have a straight possession judgment, you are not going to be able to stop the order for possession from coming unless you appeal and continue to pay ongoing rent. This is what an order for possession looks like. It's 2 pages. It gives you a time and a date, so it'll be clear. And it's never midnight. Sometimes people read it funny and they say the constable's coming at midnight. No, they're not. They're sleeping. It's going to be, like, for example, Monday at 3 p.m. And if it's not clear, you can call the district court and you can ask. But the goal is, of course, to avoid this. I just include this because I like people to be aware of what all the paperwork looks like. You can always avoid this with an appeal, as long as you can continue to pay ongoing rent. And this is information about how you would appeal. Again, it's just paperwork. There's no, oh, I hope the judge lets me appeal. No, you have a right to appeal. This is a great website. It's palawhelp.org. They even have videos of MDJ. MDJ is Magisterial District Judge. They have videos of the hearings so that you can kind of watch and see, you know, the amateur actors playing the judge and the plaintiff and the defendant, and they'll show you how to kind of bring your witness and present your evidence. But even if you don't do it how they do it in the video, it's okay. The small claims court is informal. And then the last slide is our phone number. We have a helpline. It's only open Monday to Friday, 9 to 1. But our helpline is struggling right now with staffing. So if you have trouble, you can call us at our local office, which is 610-436-4510. And we will do an intake there for you. You might have to leave a message. Again, we can only assist, we have income restrictions, so tenants up to sometimes 200% of the federal poverty line. But if a tenant calls who's not eligible, we'll refer them to a private attorney line where you can pay $25 for at least a 30-minute consult with a private attorney. We do not represent landlords. Our goal is to help tenants maintain their housing and or negotiate, work something out with the landlord. Then I have a bunch of websites at the bottom, like Housing Equality Center, which I mentioned 3 times now. They're so fabulous. And our own website. I think that's it.
Is there a place for landlords to go to?
Well, landlords have to go to the private bar because they have more you know, generally landlords have more assets than tenants. Tenants are incredibly vulnerable because you don't own your home. You don't have ultimate control over where you're living or if you have a place to live. I think there is a need for some like low bono, but it doesn't really exist. I mean, there's pro bono, which you can get a free lawyer if you income qualify, and then there's private lawyers, which is gonna be like $300 an hour, probably minimum. I'm not sure, but there's really nothing in the middle, and that people deal with that a lot. You know, sometimes people call us who are really struggling, and then our paralegal says, you're over the income guideline. But it's always worth it to call because you never know, and if you have high medical expenses or employment expenses like the train to work or the bus, or we'll spend you down as much as we can to see if you're eligible for our services.
And I just want to add that on the first Tuesday of the month here at Phoenixville Library, we have a lawyer from Legal Aid available upstairs for a free 20-minute consultation. You do need to register for that in advance. You can do that on our website, phoenixvillelibrary.org.
Is that for just tenants again, or is that for anyone?
Anybody,
Anything.
civil law, any civil law.
First
And there's also
Tuesday
no
of-
income restriction for
Right,
that.
that's right,
Because we're not opening a file, we're just talking to you,
right.
yeah.
So, I'm sorry,
Thank you,
first
Mark.
Tuesday of the
First
month,
Tuesday of the month, 10 to noon.
10 to noon.
Oh, okay.
But you have to
You
sign
have
up
to
in advance
register,
to get
yep,
an
because there's only
appointment.
so many slots.
The time.
20 minutes.
10 to noon.
10
Yep.
Can landlords just increase, like, I don't know if it's a month to month. but-
Excellent question. And that, I actually saw that today. That was one of the
Okay.
things I was dealing with the file today. Yes, the landlord can increase the rent. Sometimes they have to because life is getting more and more expensive. Other times, they're just attempting to profit more. But as long as there's notice, rent can be
No,
increased. And as
there
long
wasn't
as-
any notice.
And as long as it's at the end of a term. So it's the
Okay.
same thing I talked about before. If you're in a lease term, January to December, that renews year to year, your rent cannot be raised in May or August or October. It can only be raised at the end of December when your lease starts, right? You can only change terms in the lease at the end of a lease. You can't alter a contract in the middle of the contract. That's basic contract law. But if you're in a month to month and the
They
landlord
can-
gives you 15 days notice, hey, your rent's gonna go up
What
to,
about if they don't give you notice?
if they don't give you notice at all, and on the first of the month they say, hey, pay me 1,000 instead of 800, then you can respond politely, you know, that's not enough notice. So I'll accept the rent raise, and I understand that that'll be effective next month.
Okay.
Yeah. If they didn't give you enough notice, then the notice they gave you is effective at the next lease term beginning. Not explaining that very well, but does that make sense?
Yeah. So if it goes a year and then month to month, the landlord could raise the rent like after 2 months or after 6 months or whatever at that point.
Yeah.
Every month, if it's
Yeah.
a month.
Yeah.
And
It's a
little
month-to-month
rough,
lease,
yeah.
right.
I mean, they
They can raise
could
it.
raise it from $50 to $1 million
Really?
because there's no rent cap in Pennsylvania. But see,
Yeah.
like, everybody benefits if it's manageable rent that the tenant can afford, but that's also good compensation for the property, you know? So it's really not, like what I saw today come across my desk was somebody's rent that went from $1,200 to $1,575.
Oh.
And that was one raise. Like, that's not gonna be manageable for the tenant, and so that's gonna be bad news for the landlord in the end, because tenant's gonna fall behind more and more,
Yeah.
then the landlord's gonna sue, they're gonna have to spend $200 on that, then they're gonna have a hearing, and the tenant could draw it out just to, you know, because they don't wanna be homeless.
That's what happened to me, it was $200, she raised it.
Right,
Yep.
so, you know, if you have to raise it, it's good to have a conversation, like, look, my cost of living is going up. I know everybody's struggling, but what could you work here? And sometimes, yeah, it's hard for everyone out there, but, and in the end, yes, they can raise the rent. We don't have a cap We really need a cap in Pennsylvania. Like some states, they have a law that the landlord can only raise 10% at a time, for example. But we don't have that law in Pennsylvania. We're pretty conservative when it comes to landlord-tenant law. Some states have good cause restrictions for non-renewal, and a landlord could only issue a non-renewal with good cause. But here, we don't. We believe in freedom of contract, and we believe that you can contract with people, and then you can stop contracting with them when you don't want to contract with them anymore, even if it's their home of 35 years,
Wow, that's so, wow.
which is really sad.
Very sad.
Yeah, but that's why it's great that we have so many landlords who care and who are like, you know, I know this is your home, and I'm not gonna do that to you. I'm gonna work with you, and yeah. I just, from my desk, I don't often see that, because of course the people that are calling me are the
Like the
people
ones, yeah.
with problems.
Yeah.
So that's why when I give these presentations, I've realized over the years that they're quite tainted, and I'm like pretty harsh on the landlords, and so I do apologize for that.
And I was thinking too, like, I mean, again, if a landlord has a very like, let's just say awful tenant
Mhm.
for whatever reason,
Yeah, it happens.
I mean, rather than go through all this, I mean, it would be a lot easier to just make it unreasonable and say, hey, yeah, it's going up $500, and if you don't like it, move out.
Well, that's interesting. I've seen people do that, but I actually don't think it makes sense, because you could just issue a non-renewal. Like, you know, you're doing the same thing effectively.
Okay, so you could just do
Because you
non-renewal.
can only raise the rent at the end of a term, and what else can you do at the end of a term? Not renew the contract.
Renew the term, yeah.
Okay.
So, you know, but then the other thing is, if you don't renew and your tenant doesn't have anywhere to go, it's likely that they're gonna take you through the appeal process to gain additional time. And what you're doing by suing them is sometimes making it harder for them to move,
Yeah.
right when they're trying to move.
Right.
So like I've seen a catch-22 where this family is like in earnest, like, cause there's some tenants that are not in earnest,
Yeah.
and they're just messing around, and I've seen it. But there can be a family that's in earnest trying to move,
Yeah.
and then the landlord gets tired of waiting and sues them. Well, then all bets are off. Like, they're not moving because you can't find anyone to rent to you while you're being sued.
Yeah.
It's like almost impossible. Yeah. But thank you all for listening.
Yeah,
Lovely.
no, it's great.
Any questions from anyone on Zoom?
Yes, I have a question. I have a friend who has their adult daughter still living in the house, and she just won't leave. There is no lease. The mother has asked for the daughter to pay rent or at least pay the PICO bill, and she just refuses.
That sounds like it.
If there is no lease, what can you do?
Okay, good question, and this also comes up quite a bit. So everything that we talked about today was for when there's a landlord-tenant relationship. The relationship is key. If there is no landlord-tenant relationship, none of this applies, and you are in the realm of ejectment, which is different from eviction. Ejectment is, I own the property, there's someone there that I don't want to be there, and I want them to leave, but they won't. So basically the situation that you're describing, but it's not done in the magisterial district court. The small claims judges don't have jurisdiction over that, only the county court judges. So the homeowner would need to file an ejectment complaint, which is not a simple form like this. This is to make it accessible for the everyday man. An ejectment complaint, you know, they would probably want a private attorney to write that up for them and make sure it's served properly and verified and attached. Yeah, that process can be long. Eviction can take place in as short as 30 days if nobody contests it, but ejectment, no, at least several months.
Okay, thank you. I'll look that term online, ejectment.
Yeah.
Anything else from folks on Zoom or in the room?
Yeah.
I have a question, but I can.
Okay. At the end.
Yep.
All right. Thank you.
Well, Kelly, thanks so much.
Yeah.
Great presentation again.
Yeah, it really is.
Thanks everyone on Zoom for tuning in, and everyone in the room for coming out. Good night.